Thank you, Mr. Chairman, distinguished members of the committee, Mr. Daroff, colleagues, friends, courageous clients. I am Kenneth L. Marcus, chairman of the Lewin D. Brandeis Center for Human Rights Under Law. I apologize for the long title. I am deeply moved by your attention to this issue today at a time of great difficulty in this country. Nothing could be more symbolic of the friendship that at this moment, with everything that is going on here, the first order of business should be a concern about the diaspora. To me, this symbolizes that while in the United States, as in Israel, we might have different opinions, we are all one people. And I think that that is the fundamentally important issue that I would like to discuss. During the George W. Bush administration, some 19 years ago, I was disturbed to see that while I had the authority to support the civil rights of students at colleges and universities on the basis of race, color, national origin, sex, disability, and membership in patriotic youth organization, Jewish students were generally denied protection based on the omission of religion from our statute. And for that reason, it was necessary to establish a new approach to sometimes referred to as the Marcus policy or doctrine, under which members of ethno-religious groups who may be said to be a people have the same degree of protection as members of ethnic groups that do not have religious traits. It was important, though, to establish that the Jewish people are a people and not just members of a shared religion, in order to make sure that Jewish students receive the same civil rights protections as others. This we established in 2004. I was sad, though, many years later when I returned to that same position during the administration of Donald Trump, that there were still problems. Because in many circumstances, the anti-Semitism that we saw on college campuses took the guise of anti-Zionism. We knew what it was. It was anti-Jewish hate, but it looked like something different, like something political. And it was important to show that under certain circumstances, what appeared to be political was in fact an attack on a people, not just a political disagreement, nor a religious disagreement, but the sort of bias that should be encompassed within the same civil rights laws that protect members of racial and ethnic minorities. Informally, I began to use the so-called IRA, working definition of anti-Semitism, and then formally, President Donald Trump established the use of that definition through an executive order on combating anti-Semitism. This has been an important advance, but it's not far enough. We were pleased very recently that, as Mr. Daroff indicated, there is a national strategy on anti-Semitism that was issued by President Joe Biden. And it does, as he indicated, indicate that the IRA definition has been embraced. At the same time, however, it also welcomes and acknowledges the nexus definition, which is a less protective definition, a challenge for us. 12 years ago, early in the history of the Lewin D. Brandeis Center, we found that in many circumstances, extreme anti-Zionist speakers were creating a toxic environment for Jewish students by turning hearts and minds against them. What we found today is different and worse. It's not just an indirect polluting of the environment. There is now a targeted exclusion, a shunning and harassment of individual Jewish students. Efforts from Berkeley to New Paltz, from Vermont to Southern California, to exclude Jewish students from student government positions, from book clubs, from sexual assault survivor groups, and so on and so forth. In other words, not just bad words, but conduct, which attacks, marginalizes, and excludes Jewish students based on that part of their identity as Jews, which is committed to the state of Israel. At the University of California at Berkeley, 9 student groups, and now arguably as many as 22, have changed their charters or constitutions to include bylaws that state that no one who is a Zionist or supports the state of Israel may speak to these organizations on any topics. This is not just directed at extreme political positions. Anyone who supports the state of Israel and believes that it should have a right to exist is therefore excluded. We have to understand that this is not a rule against people of a particular party or political view. It is a rule against Jews. There are, I would argue, three things.
Where, excuse me? Where
This is the University of California at Berkeley School of Law, my alma mater, although when this was adopted in August of last year, it was the only law school where we know of that this was happening. But now the anti-Zionist protesters are bragging that they are beginning to spread this to other law schools around the United States, and it would not be surprising to see a significant expansion at other institutions. There are three things I think we need to understand. First, a rule against Zionists is a rule against Jews. When they say no Zionists, they're not talking about a political viewpoint. They're essentially saying no Jews in the same way that a rule against people who support the Vatican is effectively a rule against Catholics. There may be some Catholics who are critical of the Pope. There may be some non-Catholics who support the Pope. But when you say no supporters of the Vatican may speak, you are effectively saying no Catholics. We need to understand and state clearly that a rule against Zionists is a rule against Jews and needs to be treated that seriously. Second, we need to establish the IRA working definition of anti-Semitism as the only legal and policy approach to defining anti-Semitism for official purposes, rather than coupling it with other definitions which will be more lenient and which provide exceptions that enable anti-Semites to evade even the description of anti-Semitism. Third, we need it to be understood, acknowledged, and broadly recognized that Zionism is integral to the Jewish identity of many diaspora Jews. That is to say, when you exclude someone based on their Zionist views, you are excluding them based on who they are as Jewish Americans. That is not just impolite. It is not just politically incorrect. It is a form of hate or bias that the civil rights laws must recognize to the same extent as every other form of discrimination. I would not say that Zionism should be acknowledged as a protected category. Rather, Jews are members of a protected group, and Zionism is integral to Jewish identity. It is that formulation under which courts and policymakers in the United States and elsewhere can understand that this is neither an overreach nor an effort to take positions on a political debate, but rather basic anti-discrimination law and policy. Thank you, Mr. Chairman.
Thank you.